Welcome to our presentation on Social Security Disability Process and Prospects. My name is Glenn Cinco. I practice law in Pennsylvania with my spouse and law partner, Betsy Zimmerman. Together, we've been representing individuals before the Social Security Administration for more than 30 years. Please understand that the following talk will consist of general information and our opinions. None of the information that we will be providing should be considered as case-specific legal advice. Social Security claims are extremely fact-specific, and the application of the law to those facts is very nuanced. Our talk today will not form an attorney-client relationship. First, we believe that it is critical that you come to grips with the idea of your disability. After a lifetime of working and taking care of others, it is often very difficult to reach the conclusion that you are disabled. Success in this endeavor, however, is simply unlikely unless you are able to accept and express to the Social Security Administration the full extent of your functional limitations.
To determine what type of benefits you may be eligible for, please go to mysocialsecurity.gov and sign up for an account. Once you have your account, you can go online and see what your earnings have been over your working career, what your retirement rate would be at your full retirement age, and also what your disability rate would be at the time that you log on to check. You can also see how many credits you've earned, and Glenn will be talking about credits later on in the presentation.
Let's begin our discussion today by reviewing the primary types of benefits that are available under the Social Security laws. I imagine when most people first talk about Social Security, their thoughts turn to retirement. These are the monies that they expect to receive after their working careers have come to a close. But Social Security isn't just for retirement benefits. The Social Security laws provide for benefits for disabled individuals, and we call those benefits Social Security disability benefits. If you have worked and paid into the Social Security system through your withholding taxes, you may well be eligible to receive these benefits long before you reach retirement age. Hand in hand with those benefits come Medicare benefits. When we talk about Medicare, this is the same program that we all receive when we turn age 65. However, if you are a disabled individual and recognized as such under the laws of our country, you may receive Medicare benefits long before age 65. If you haven't worked a sufficient number of years or paid a sufficient number of dollars into the Social Security system, but are disabled, you may still be eligible for some benefits. Those benefits fall under the Supplemental Security Income laws, and they mean exactly what they say. They are there to supplement whatever other resources that you have. So we have disability requirements and financial requirements to consider when we look at supplemental security income. Much as with Medicare and Social Security disability, Medicaid goes hand in hand with supplemental security income benefits. We will get into the qualifications for all of these types of benefits in our next section.
Keep in mind, once you receive an award of benefits, there could be offsets. The amount you receive in Social Security could be offset against the amount you receive in long-term disability benefits. Also, there could be changes in any state-sponsored medical insurance or state-sponsored cash assistance programs for which you've been eligible.
As we go forward with our presentation, we are going to focus on Social Security disability benefits. The Supplemental Security Income Program can vary widely in its application and scope from state to state. The Social Security Disability Program, however, is uniform throughout the country. Looking to the benefits that are available under the Social Security Disability Program, we first consider monthly income. The amount of monthly income that you receive if you are awarded Social Security Disability benefits is entirely dependent upon how much and for how long you have paid into the system through your payroll withholding taxes. Let's look at the benefits that are available under the Social Security Disability Program. There are three main benefits that we need to consider. First is a monthly income. Second are medical benefits. And third, there may be benefits available for your dependent children. The monthly income amount that you receive if you are awarded Social Security Disability benefits is entirely dependent upon how much and for how long you have paid into the Social Security system through your payroll withholding taxes. Once that is determined, a monthly amount is provided, and that amount can vary from literally just a few dollars all the way up to over $3,100 presently. The medical benefits that are available for someone who has been declared disabled under the Social Security Disability laws are the same benefits that are available through the Medicare program. The Medicare program that we all know starts at age 65, but for someone that is disabled, that program starts much earlier. There is a concept in Social Security Disability law called the onset date. That is the determination made by the Social Security Administration as to when you became disabled. Counting forward 30 months from that date, we find the eligibility date for your Medicare benefits. There are no medical benefits provided under the Social Security Disability laws during that 30-month period. Lastly, we need to consider whether or not you have any dependent children. If so, those children may share equally up to 50% of your monthly income payment. That's as an additional payment, not a subtraction from your monthly amount. Depending upon how many children you have, and if they are all dependent, the Social Security Administration will calculate a figure and make that payment available to your family to help supplement your monthly income as well. Now that we have talked about the programs and the benefits that are available through those programs, let's talk a little bit about the qualifications for you to receive those benefits. We turn first to the issue again of your work history. That will be a recurring theme throughout this presentation. Generally speaking, the older you are, the more work credits you must establish before you can qualify to receive Social Security Disability benefits. A work credit is established by earning a certain amount of money in each year, and you can obtain up to 4 credits in any one given year. Hand in hand with the idea of work credits is also the timing of your work history. The law provides a date last insured, and that's the Social Security's term, that we must take into consideration as we consider whether or not you are eligible for these benefits. The date last insured is simply the last date before which you must prove that you are disabled under the law. And that date goes hand in hand with when you stop working. Generally, like any insurance program, you pay a premium. In this case, the payment is made through your withholding taxes. Once you stop working and stop paying taxes, you're no longer paying a premium for this insurance. When that occurs, the Social Security Administration will calculate how much you have paid in and over what period of time, and then establish the last date before which you must prove that you are disabled under their program. Again, generally speaking, it can be no more than 5 years after the last date that you worked. However, in some instances, it can be dramatically shorter. We also must establish that you have a medically determinable condition. This is a term of art used by the Social Security Administration, and it really means, do you have a working diagnosis, such as AIH, PSC, PBC. These are the diagnoses that your doctor has established to describe your condition. It is a fundamental stepping stone that we must achieve before we can go further in determining your qualifications. Simply put, if we can't determine what is wrong, then the Social Security Administration will not consider the symptoms that you express. We also must look at whether or not you have an inability to engage in substantial gainful activity. And again, that's a term of art used by the Social Security Administration. What we're really discussing here is, do you have the ability to work 5 days a week, 8 hours a day, for a total of 40 hours per week? And can you do that for 50 or 52 weeks a year? We must keep in mind that the way that you and I might talk about the term disability over a cup of coffee is very different than the way that Social Security considers that term. Disability for them does not mean simply that you are not able to do your regular work, or even the work that you would like to do. For Social Security, when they consider the term disability, they look at whether or not you are able to engage in any type of substantial gainful activity, or really any type of work. So to make it even more clear, if you were the proverbial rocket scientist at NASA but couldn't do that job anymore, that would not be enough to get you an award of Social Security disability benefits. You would also prove that you are not able to be the secretary or the doorkeeper or the gate guard at NASA either. In other words, it's not just the work that you've been trained for or the work that you've done in the past that comes into play. It's every conceivable job that your physical and mental condition might allow you to perform. When I sit in my office and talk to clients about this concept, we go through a long discussion about all the different types of jobs that exist and how those jobs do or do not apply to them at any given point in time. We inevitably wind up discussing a core of unskilled entry-level work that exists by the tens or hundreds of thousands throughout the country. And that is what the Social Security Administration will focus on when they look to see whether or not you are disabled. So the first step, of course, is to show that you're not able to do the work that you've done in the past. But the second and equally important step is to show that you are not able to do any other type of work either. It will be important for you to be able to prove that your disability is not temporary. You must be prepared to convince the Social Security Administration that your disability has lasted for at least 12 months or is expected to persist for at least 12 months. As we look at conditions that fall under the general category of chronic liver diseases, we know that these conditions are long-lasting. Now that we've looked at the basic qualifications that you need to prove for your eligibility for these benefits, let's take a closer look at what Social Security uses to make a determination as to whether or not your claim merits an award of benefits. There are several different processes that the Social Security Administration uses, and one of them is what we refer to as the grids. It's really a matrix or a spreadsheet that employs certain terms such as your age, your education, your work experience, and the transferability of any skills you may have developed during your working career. Depending how all those factors come together, the Social Security Administration has established a ruling, and that ruling will determine whether or not they will award benefits for you. Clearly, someone that is younger and more educated will have much more difficult time achieving an award of benefits than someone who is older and less educated. This matrix that is developed is played out against the backdrop of your physical capacities, whether or not you are able to work at a sedentary level, which is primarily seated and lifting no more than 10 pounds on a regular basis, or a light level, which can involve sitting or standing and lifting up to 20 pounds, or medium work, which is done primarily standing but involves lifting up to 50 pounds. Once the Social Security Administration has established these parameters, they plug into the spreadsheet and reach a conclusion that's determined by their own rules that are well known and well established. Another methodology employed by the Social Security Administration in determining an award of benefits is to consider the regulations established for specific listings of impairments. Specific listings of impairments are literally dozens and dozens of pages referencing various body systems, the musculoskeletal system, the cardiac system, and more relevant for us, the digestive system. Within the digestive system, the Social Security Administration makes an allowance for an award of benefits for chronic liver disease and for liver transplantation. It is important to know that there is no specific listing that references autoimmune hepatitis. As we dig deeper into these regulations for listings of impairments, I find it helpful to consider an onion. And as we go through the regulations, we're essentially peeling back an onion, finding more and more information and more detail. Chronic liver disease for the Social Security Administration is merely a catch-all term. It alone will not get you to an award of disability benefits, because we must show with the diagnosis of chronic liver disease the presence of various other conditions, symptoms, and signs. These can involve the renal system, these can involve the cardiac system, they can also involve the pulmonary system. Once we start to consider an award of benefits for chronic liver disease under the regulations of the Social Security Administration, we see how important various testing is. Serum albumin is a very important factor for them in consideration of an award. We also see how important the frequency and the intensity of your symptoms can be. It is extremely important to consider as we go forward that the Social Security Administration will not merely accept your word on the intensity of your symptoms. They will not merely accept your word on the frequency of your symptoms. As an administrative law judge once told me, if I don't see it in the medical records, I'm not really giving it a whole lot of weight. So this is where the partnership between you and your doctors come in. It's important to express to them how frequently you are experiencing the symptoms that you have and how intense they are. How that's described is really a matter for you and your doctor, but however you describe it, it's important that it gets into the notes, because your testimony alone will not, at least in my experience, carry the day.
As Glenn has said, it's important to have a diagnosis. Now, most of us here have already received a diagnosis of AIH. However, there may be more conditions and additional diagnoses that you need to receive. Please remember to keep working with your doctors to pin down all of the conditions that you have, because cumulatively they can help you in applying for disability. You also have to remember that going into a hearing before an administrative law judge and just saying, I don't feel well, I hurt, I'm tired, is not going to be enough. You're going to need your doctor's medical records to support what it is that you're saying.
Before we leave this particular methodology employed by the Social Security Administration, I want to urge you to refer to the materials that we've provided to you and look particularly at listing 5.05. This is the listing for chronic liver disease. I would encourage you to take it to your doctor and to have a discussion with him or her about the terms that are laid out in that regulation and whether or not they apply to your individual case. Remember again how you feel, your expression of symptoms, and what the doctor may think may not be enough. The Social Security Administration relies heavily upon objective evidence. So let's get the blood test, let's do the diagnostic study, and then let's correlate that with the clinical exam and the expression of your symptoms to form a picture and a package that we can present to the Social Security Administration and have them look at this through the lens that they've established. A third, and by far in my experience, most common way of getting to an award of Social Security disability is through what Social Security calls a Step 5 analysis, but it's really a vocational analysis of your claim. This occurs most frequently during the course of a hearing that's held before an administrative law judge. And here we're considering what your functional limitations are. Once those are established, a vocational expert will help apply those limitations to their knowledge of the workaday world and make a determination as to whether or not you could meet the expectations of an employer with regard to performance at work in a competitive working environment. So to unpack this, we need to start to look at whether or not you have a work history. Remember I said we'd come back to that work history and those work credits. The first part of this type of analysis is what type of work have you done in the past and what skills have you acquired during the course of that work. We need to then analyze whether or not those skills are transferable to some other type of work. For example, if you were a car salesman, you can probably also sell refrigerators. However, if you were a mechanical engineer designing bridges, it's going to be a lot harder to make you a mechanical engineer designing automobiles. These are specific engineering skills that may not transfer from one set to another. We also need to look carefully at what your diagnosis is. Remember I gave you the concept of a medically determinable condition. Fancy way for saying diagnosis. From that springboard, we need to establish that your symptoms are relevant, correlate, and are typically associated with the diagnosis that your doctor has established. Once we have those parts all pulled together, we then have to examine the frequency and intensity of your symptoms to see how they affect your ability to function on a day-to-day basis. In other words, what have you done? What is your condition? Does that condition likely associate with your set of symptoms? And if so, how intense and frequent are those symptoms? That's really the crux of this type of analysis. And so, let's look at what symptoms we would typically find in an AIH setting. Do you experience fatigue, nausea, abdominal pain, joint pain? These are the types of symptoms that you need to express to the Social Security Administration. But before we ever get there, we need to make sure that those symptoms are expressed to your doctor. When I sit and talk with my clients at the beginning of a case, I ask them, how are you doing today? And almost all of them will tell me, okay, I'm fine, it's okay, something of that nature. Then I ask them, when they go to the doctor and the doctor's nurse or the doctor himself or herself asks, how are you doing? How are you feeling? They typically respond the same way. I'm okay. It's fine. Not the greatest, but all right. Well, I then explain that those terms are exactly what gets put down into the doctor's notes. And when the judge takes a look at the doctor's notes, he'll wonder, why is it that you're complaining of a set of symptoms here in the courtroom, but the notes seem to indicate that on any given day you're doing okay, or fine, or not so bad. So, what I tell my clients to do is when that doctor or the nurse asks that initial question of, how are you? Instead of giving the knee-jerk reaction of fine or okay, that you start your phraseology with, today I feel, and then lead right into your set of symptoms. Remember that ALJ that I referenced before? If it's not in the medical records, he's not giving it much weight. Well, that's pretty consistent throughout the system. So you need to make sure that your symptoms are expressed in your doctor's notes every visit that you go. That's the first step. The second is to express how intense they are and how long they last. Do you have nausea? Is that for 5 minutes after eating? Or is it for several hours during the course of a day? Do you have pain? Is that transitory or is that constant? These are the things that you need to discuss and make sure get into your doctor's medical records. It's also important to remember that we're not just considering the working diagnosis of AIH and its symptoms, but we're also considering the medications that you are being given and their side effects. Do the medications cause sleep disturbance? Do they cause a brain fog? These are also equally important symptoms to express to the doctor and to make sure get into your notes. Once the notes establish that, it provides you with a strong foundation from which to testify to an administrative law judge about how you're feeling and how you're functioning. Because the truth of the matter is that if you're going to miss 2 or 3 days, a month from work because of your symptomatology, you're not truly employable. If you can't stay focused on your job throughout the majority of the workday, I don't know any employer that's going to allow someone to miss 30% of the day, 20% of the day because of their symptoms. If you're not sleeping well at night and you need to take a nap during the day, that's something to express to the doctor because it's going to be an important factor in your claim. No employer that I've ever worked with has said it's okay for their employees to take an hour break in the morning or an hour break in the afternoon, in addition to all the other breaks and lunch breaks that they get. That's what Social Security is looking at in this vocational analysis methodology. They want to see how you are functioning and how your function will fit into the competitive working environment.
Glenn has discussed the three methods for qualifying for disability benefits: the grids, the listings, and the vocational aspect of it. What I recommend is that you look at all three combined, and in doing so, establish before administrative law judge, if your case has to go that far, that you're unable to work 8 hours a day, 5 days a week, 50 weeks a year because of your diagnoses, because of your symptoms, because of the side effects of the medications that you take.
It's helpful to remember that the Social Security Administration looks at your claim with a very wide scope. That is, they're not just looking at your diagnosis of AIH, they're looking at you as a whole person. That means that while your interactions with your doctors may be focused on your liver disease, it doesn't mean that that's the only problem that you might have interfering with your ability to work. Do you have arthritis? Do you have a degenerative disc disease or degenerative joint disease? Is there something going on with the pulmonary system that may not rise to the level of a specific listing of impairment? These are considerations that the Social Security Administration will take into account. And so as you're discussing your case and making your claim, it is important to consider yourself as a whole person. The claim is more than just a single diagnosis. I think Betsy gave you a helpful hint about that, and it certainly will come into play as your case proceeds. We've talked a little bit today about the importance of your doctor and your doctor's notes. These are a primary source of information for the Social Security Administration, but they're not the only source of information. Please don't forget that the notations made by the physician's assistant, by the nurse, by your physical therapist, these are also equally important to make sure you have access to, and you make sure that you tell the Social Security Administration about their existence. Don't overlook the role of your pharmacist's records. The types of medications that you take and their dosage and frequency can give a very strong clue as to the intensity and persistence of your condition and symptomatology. Once we move beyond the realm of the medical professionals, it's important to consider your family and friends as additional sources of information. Make no mistake, the Social Security Administration will not give as much weight to their opinions or their statements as they will to the doctors and other medical professionals' notes. However, no one knows you better than your family. No one knows you better than your friends. If you can reach out to them and have them describe for the judge or for the administration at the earlier stages what your life is like and how they view it, that can be very helpful. The format that I have used with great success is for a friend or family member to compare your activities, your personality, your engagement with your community before your condition progressed to the point where you were claiming a disability versus what it's been like since that point in time. Nothing fancy is required. A simple paragraph or two in a letter format is more than sufficient, but it's an opportunity to express to the Social Security Administration additional information which may not otherwise be readily available. An important consideration that is often overlooked is just who is receiving the information that you're sending. In all of the years that I've been practicing before the Social Security Administration, I have yet to run across an administrative law judge or a clerk in a Social Security office who is a trained physician, let alone a specialist such as a hepatologist. So, keeping in mind that these are non-experts who are going to be receiving all of the medical records, it is important to make sure that those records are clear and the significance of test results are well explained. Sometimes that happens right in the record itself, and other times it requires a short narrative statement, a paragraph or two from a doctor to explain why this blood test is significant for the diagnosis, or what it reveals about the symptomatology, or how it reflects upon the impact of medication. Consider who your audience is when you're presenting these records. And yes, the Social Security Administration does have its own set of doctors that it can call upon and refer matters out to. However, my experience tells me not to rely upon their interpretation of your doctor's records. It's much better to have your doctor offer an explanatory note along with those records, if possible. Now that we have familiarity with various programs that are available and the benefits that attach to those programs, now that we've considered the qualifications and the methodology used by the Social Security Administration to make a determination as to whether or not your application for benefits will be awarded, let's take a look at the application. The application is available to view online. It can be completed and submitted online. You can also apply over the telephone, and you can also receive a blank form completed in handwriting and submitted to your local Social Security office. During the pandemic, those offices have been largely closed, and you would need to mail it into the office. Before you begin to fill out the forms, I suggest that you take a look at them and see just what information the Social Security Administration is requesting from you. Once you have reviewed the application form, you will know that you'll have to gather certain types of information. In addition to that information, the Social Security Administration is looking for other documents, such as your birth certificate, such as a marriage license. Please reference our documents that we have included for your review to get a full listing of what you should have gathered together before you make your submission to the Social Security Administration. You also will want to take a look at your work history, again, to make sure that it is current, up to date, and accurate. Before you submit that application to Social Security, you'll want to review your claim with your doctor. Not for his legal expertise, but to make sure that you have appropriate documentation of your conditions and that your symptoms are well documented in his or her charts. Lastly, at this point, you want to make sure that you are prepared to wait. Now, that simply means that this process can take months or even years. If you are going to be without income from a job or career, it's important that you determine how it is you are going to survive financially while this process is playing out in front of the Social Security Administration.
One of the other things that's important as you've applied for Social Security disability is to understand the process is not over. Of course, you're going to continue to see your doctors, continue your medical treatment, but you're also going to start receiving paperwork from the Social Security Administration or from an attorney or advocate if you have one helping you in this process. It's very important that you review that paperwork, complete whatever you need to complete on it, and return it to the attorney, advocate, or to the Social Security Administration promptly. Any delay by you could be a delay in your case. This is especially true should you receive an unfavorable decision and you want to appeal. There are certain dates by which you must file an appeal, and you have to be very careful not to miss those filing dates.
So now that your application has been submitted, the inevitable question is, well, what are my chances? What are the prospects for me to get an award of benefits? I can tell you that each case is individual and unique. Your set of facts will be unlike anyone else's. How the Social Security Administration looks at those facts is simply unknowable at the time that you submit your application. However, we do know that last year, approximately 35% of the people that applied for benefits were awarded those benefits upon their initial application. The average monthly benefit that is awarded was $1,424. The maximum benefit available to be awarded this year in 2021 is approximately $3,100 per month. We urge you not to be discouraged by these numbers. Even if you do not receive an award of benefits upon your initial application, there is a multi-step appeal process. There is a request for reconsideration, and then ultimately a request for hearing before an administrative law judge. Even if you do not prevail before the administrative law judge, there are additional steps for appeal, including an appeal to the Social Security Appeals Council, and then ultimately into the federal court system. This can be a long and drawn-out process. However, the benefits that are available to you will make a difference in your life.
In preparing to apply for Social Security disability benefits, we recommend that you speak with an attorney or an advocate that's well experienced in this process. It is a very difficult process and hard to navigate on your own, and we think that having an attorney or an advocate may increase your chances of success. It's also very beneficial to you and your case if you have a list of your doctors, their names, their addresses, their telephone numbers, and to the best of your ability, the dates you were seen by them and the treatment you received from them. This goes the same for hospitals. When you went to the hospital, what hospital, their name and address. It's best if you could keep a calendar that shows what dates you were seen, by whom you were seen. Also, it would be a good idea to keep a diary that shows what treatment you received from what doctor when. Also in that diary, you could include how you feel day to day, because one day you might be feeling fairly good, and the next day you feel like a truck ran over you. It's important that you be able to express that to your doctors and to an administrative law judge, again, if your case should get that far. Some other basic things that you might not think of is during your application process and while you're waiting for a hearing or a determination in your case, should you move or should you change your telephone number, please make sure that you notify the Social Security Administration or your attorney's office or your advocate's office so that they know how to reach you. Thank you for inviting us to participate in the AIHA conference. We hope that the topics we've discussed today have been both informative and beneficial for you. We urge you to look at the materials that we have provided, and should you decide to apply for Social Security disability, we wish you success. Thank you.